Hello, viewers. You are welcome to AICC, actually the fourth AICC COVID-19 speaker series. My name is Dr. Hadiza Osuji, and I'm the Executive Director of AICC. AICC is actually African International Collaborative Center. That is the meaning of AICC. And AICC is a nonprofit organization established for the charitable purpose of promoting and preserving African culture and ethnic pride, empowering African women and youth for success, promoting unity and diversity, and building leadership among the members as well as the youth, and collaborating with organizations, institutions, including faith-based organizations and policymakers, to develop and implement programs that matter to the African community, that are culturally and contextually relevant for the African immigrant community. In addition to that, actually, we also serve as a source of resource for the African immigrant community, and also we bridge the gap between policymakers and the African immigrant community. So I am very happy to hang out with you today once again. Today once again. And moving forward, if you could, the previous series we had Lady Chima Ekeze in the house, and based on her, her experience and challenges and the lessons learned pertaining to bereavement with regards to, somebody, she lost a significant other. So, and she had highlighted the importance of estate planning and permanency planning, and also probate, the probate, understanding the probate laws surrounding, these points. So in follow-up to that, we have an international lawyer in the house, Henry Ukazu. He's going to be introduced in a little bit. And he is going to, touch on this point and really provide some understanding with regards to the importance of estate planning, permanency planning, and also, the probate laws surrounding this. And with that being said, in the house also with me today is Ngozi Lasbury. And Ngozi would be introducing herself as well in a little while, so you get to know her a little bit better. And she will, facilitate, actually moderate this series. And without any further waste of time, I am just going to hand over the reins to Ngozi. Please stay tuned, and Ngozi, take over.
Thank you, Dr. Suji. Good afternoon, everyone, and welcome again. My name is Ngozi Lasbury. I am a member of AICC and your moderator for today's edition of our video series. With us today, as you were already told, is Mr. Henry Ukazu. Mr. Ukazu is an international lawyer, a social entrepreneur, published author, prolific writer, author, public speaker, and a humanitarian. He is the author of a widely acclaimed inspirational and motivational book, Design Your Destiny, Actualizing Your Birthright to Success. Mr. Ukazu is a graduate of New York Law School, and with over 10 years of experience in leadership development and youth empowerment. He is currently the legal coordinator for the New York City Department of Corrections. Mr. Ukazu is also the founder and president of Global Empowerment Mentoring Initiative, Inc., and Henry Ukazu Leadership and Mentoring Program. He richly employs both platforms to host Design Your Destiny podcast series and a weekly webinar on empowerment and leadership training, Design Your Destiny series. Mr. Ukazu is an influential advocate for millennials and as a powerful instrument of community and global transformation. Apart from being profiled by News 12 and the New York Times, he is also a favorite guest on various media outlets. He has enjoyed the rare privilege of a 2013 joint profile on leadership alongside the former President of South Africa, Nelson Mandela, on the topic, Making of a Leader. So you're welcome, Mr. Ukazu. We're glad to have you today.
Thank you.
Yes, but before we dive into the meat of our discussion today, can you take a minute and briefly tell us about your book? Thank you.
Thank you, Ms. Ngozi, for that rosy introduction. I'm really flattered. Somebody listening or watching you might be thinking, is somebody so big? But I'm just so ordinarily. But thank you for those good words. Well, the title of my book is Design Your Destiny, Actualizing Your Birthright to Success. It's a book about self-discovery, capacity building, leadership, and unleashing your potentials. I've discovered in life that a lot of people don't really know themselves, and that is a critical reason why they fail to succeed in life. Once you are able to discover who you are and what you have been created to do, trust me, success is just around the corner for you. So that is what I've been able to pencil down in the book to help people of all spheres of life, irrespective of your age and industry. You need to know yourself. So that is what the book is all about, self-discovery.
Thank you very much, Mr. Ukazu. Wow. Very, very robust and impressive resume and accomplishment you have there.
Yes.
So moving forward, so last week we had Lady Chima Ekezie, who, speaking from a lived experience, challenged us all to do the needful. And so we want to understand today from the legal perspective what we can do to accomplish or implement those things so that we have our affairs in order. As we all know, we are living in an unprecedented time given the COVID-19 pandemic. So as we move forward, I would like to find out from you, what is estate planning? Is it essential for everyone to consider, or is it only needful for the rich? And what would you like to tell us on that? Thank you. The platform is yours.
Oh, thank you. Well, this is an interesting question. People ask that question every now and then about estate planning, if they should do it or not. So speaking from the African perspective, a lot of people feel they don't need to plan their life and their family. Why? Because they said that they have no asset, they have no property to really share. So what's the need? So to some people, it's only when you have property or assets that you can now plan. But in reality, that shouldn't be the case. Estate planning is for everybody. It's not only for the rich. What's important in estate planning is that you remove the fear of making sure that your assets go to the people it is supposed to go to, as opposed to going to a different source that you don't really want. So estate planning is for everyone. It's not only for the rich or for a particular set of individuals. It's for everyone. It doesn't matter. If you can plan your life, daily, academical life, spiritual life, social life, or anything about your life, same way you should plan for your estate, so that when you're diseased or you leave this world, your estate will go to the rightful source you deserve, you designed for it.
Wow, that's interesting to know. So would you perhaps give us an instance of, like, when someone does not do that, what really happens perhaps among family members, and what they call the role of the court and what you do? What happens?
So I think that is where the probate court really comes in. When someone dies without writing a will, the property goes to the estates. And what I really mean is that the court now takes over. Okay, So the court will not have to either appoint an administrator that will be of the best interest to the deceased and then to the living distributees. So a distributee is someone that's a living person, but the disease is there. So if, for example, now my dad is deceased, okay, and then I might be a distributee, meaning that I am living. So the court might decide to appoint someone, one of these living offspring, to take charge. However, the living children of the deceased are encouraged to choose among them who will now be the administrator of the property or the estate. Where they can do that, the court now comes in to really administers the court. And depending on the amount of the estate involved, then that determines the amount you're going to pay. So for example, if you have a large estate, the amount of money you pay can be a fortune, and that can take a lot of time to really execute the estate. But if you have a small estate, now the money you pay might be less and you might get it sooner. So it's strongly advised for people to plan themselves, have a will, because when you don't have a will, you not die intestate, meaning you die without a will. Your asset or your properties goes into the probate laws of New York State. Then New York State now takes sole custody of everything. Now, if someone is disputing any particular claim, for example, because there are so many intricacies that comes with probate laws, and this is something nobody wants to really engage in. And I'm going to give you a practical example. My late mom passed away 2 years ago, right? So there was no, she has no will. Before she passed away, she did not say this is how her will is going to go through. And we did not even think about it. We did not even emphasize that she's going to go through that route. And I was assigned to be the administrator. So when I was assigned, that was a process for me because I have to make sure all my siblings consent to it. So the court will give you a form. That form the court gives to you, you have to give it to each person that is a sibling, then that is a distributee or an offspring of the deceased. Now they have to all sign that form and consent that they want you to be the administrator. And then in doing that, they have to provide evidence, either their green card, citizenship, and then their social security number. They give it to you, we now take it to the court. Then those documents have to be notarized. When you get to the court and you file it and the court approves it, now you now have to go to the agency. It's a bonding agency that will now have to evaluate all those papers. And in doing that, you must make sure you have the document, like the insurance papers from the court, from insurance, for example. You take it to the court, take it to the bonding agencies. Everything has to be a match with the amount of money. And that document has to be notarized. So when you do that and the bonding agency approves it, then you take it back to the court before the court will now, when the agency approves it, then the money will now be released. So it's a whole lot of process. So you want to save yourself the headache of going to probate. Sometimes it takes months. It takes months and people get frustrated. But if that document was signed by the deceased, trust me, within a day or two, the money will be available, and then you can now take care of all assets, all properties, or any bills you really want to pay. However, some of these assets might not go into probate. For example, when it involves things like when it involves life insurance, accounts, and retirement plans, yes, those ones don't go into probate. Why? Because they have a beneficiary, if there is a beneficiary. So for example, if you have a retirement plan that has a beneficiary, if you have a bank account that has a beneficiary, and if you have a retirement plan that has a beneficiary, those ones don't go into probate because the beneficiary takes it automatically. It is right there. But it's only when they have no beneficiary that it now goes into probate. Then the state law now takes control of everything. So to save yourself of this headache, it's better you have all your wills structured. And for that, and for those three aspects I mentioned, it goes into what I call the trust. Now, the rules of trust does not work with probate because they have their own rules and regulation that governs the trust. So whatever the trust says, that is what the trustee carries out. Well, it's a little bit technical because estate and trust is a little bit big, but the big picture is if you have no will, it goes into probate, which gives the court the power to administer your property, and we can take a lot of time.
All right. Thank you. Ngozi, if I may interject at this point, just a quick question. Since now, if I have beneficiaries on my life insurance and my retirement accounts, for example, the 401k and my bank accounts, if I have already, stipulated, beneficiaries for these accounts, then is it okay for me to say, but I don't need to write will anymore since already I have assigned beneficiaries to, my estate, so to speak. So, right? No,
No, you must have a will because a will is different. No, because a will talks about how your estate will be distributed. Because once somebody is deceased, there's a document. I don't work in that wills area, but I have an idea because I've done it before. When my mom passed away, I did it for my siblings. This is something some lawyers are paid a lot of money for, a lot of money. Some lawyers have been paid huge amount of money to do this. And even when I was in law school, we were taught how this has been done because there are so many forms you have to fill out. So you may have a retirement plan, that is one. You might have 401k, you might have beneficiary, you have bank accounts. This was normal. But then you must also have properties elsewhere. So that tells you again, you still have to do your will. Because there are so many things you have to, there are so many boxes you will check. When the court is satisfied that everything has been checked, then they will now approve of it. So it's not about you have a retirement plan, you have bank accounts, and then you now have life insurance. You say you won't do your will. No, a will is like everything you have, your whole being is attached to your name. So that is what happens.
Wow, that's quite interesting. And may I use the opportunity to say that I'm sorry for the loss of your mom.
Yes.
And so you mentioned a bit about trust. Is there a difference then between a trust and a will, or they can serve the same purpose? If you can expatiate.
So a will basically talks about how your property will be distributed, okay, when you pass away. So trust again is like you saying, this is your own property, this is your own assets. Now you can now decide to give it to a trustee. A trustee in that person will now be the person that will now administer the estates whenever you are not there. However, there are some requirements that the trustee must follow. Okay, you cannot use what the trustee, what the executor, the person who owns the property has given to you for your own personal benefit. That means you cannot commingle the funds. So a will and a trust are two different things. Just like I was talking about the trust, they have their rules. There's a rule that governs trusts. Why there's a rule that governs wills? So these are two different entities, but they may have similar concepts, but they have rules that governs them. Like for you to make a will, there are several requirements in making a will. Number one requirement is that you must be of full age capacity, which the law requires us. You must be 18 years, right? Same thing with a trustee. Now for the will, okay, the testator, whoever is making that will must sign the documents. And then in doing that again, you must also sign at the end of it, thereof, you must sign that document. Then the fourth requirement is that you must acknowledge that will in the presence of two witnesses. But a big point, which is the fifth point of a will, is that it must be publicized. Publication is very, very important. If a will has not been publicized, a will not go into effect. Now you must have two witnesses that must attest to that will. Two witnesses, and those two witnesses must not have an undue influence on you for them to really attest. There must be two individuals. And when you sign your will, you're part of it, these two other witnesses must sign theirs within 30 days. That's what the law requires. But for trust, it's a different thing entirely. So there are different there are different part of it in each of them.
Okay, great to know that. So you also mentioned that for a will to be in effect or be effective, that it has to be published. Can you help us understand what you mean by being published? Is it that within the court system, or it has to be publicized in a media, like in a newspaper? Can you tell us a bit on that?
So everything comes in maybe in that same perspective, because it's just like you're telling the whole world when you get married. Now, okay, let me say, if someone changes the name, my name is no longer Miss, I am now Mrs., or I change the name, you have to do publication, or it's like a gazette. So publication literally entails telling the whole world, this is it. So when you're no longer there, they will now see that, okay, yes, you have a attorney was with it. Probably it was in a court record, or it was with a bank. There was a ceremony that took place that people know that this is your will. It must be publicized for the whole world to know. It is not one thing you will do in your closet. There must be a third party that knows about it. So that's the word publication. Without that, you have no will.
Wow. Thank you for that clarification. So my next question will be, we're here in the States, in the diaspora, so a lot of us have properties here, and many of us do not have any. But even at that, we have most of the bulk of our assets in our home country. For instance, Nigeria, many of us have big houses, big bank accounts, and every other thing over there. So would you also advise that they do the same thing? Because, as the African person, we know that death obviously is inevitable, but most times we tend to overlook that as if we're never going to die. And what would you say to that African man or woman in terms of getting himself in order, both here and at home?
All right, I'm going to approach this from an inspirational perspective. I always tell everyone, and this rule is universal, failing to prepare is preparing to fail. Now, you will live in a civilized world where the laws and rules and regulations are at least manifestly seen to be upheld. Now, if you come to an environment and you see that the system is working very well, a rational mind will want to adopt that same thing and take it and then apply it in his or her own life. Now, for people who are in Africa, who have properties, who have assets, who have money in their accounts, whatever the case may be, it is very, very imperative and highly recommended that not only you will insure these properties, but then also have a will that will say this is what you will do, how your will be distributed when you are no longer there. Saying that, oh, well, I have to make $1 million, I have to make $1 million more, I have to make more money so that I will have more properties to share. It doesn't make sense. If you have just one property, right there and then, when you finish your paperwork, it will make more sense for you to assign that property to somebody else, to the extent that the next day you're no longer alive. You don't have to wait for a particular time before you can share your property or you assign it to whoever you want to give it to. So I would strongly advise and recommend to anyone, it doesn't matter where you are, if you're in the US or any part of the world, always have at the back of your mind that death is inevitable. It could come in at any point in time. So the earlier you plan and prepare, the better for you. For me, I always say this, I prepare for the best and I expect the worst.
Thank you for that. Well, obviously, everyone that is listening, you've heard what Mr. Ukazu said. Let's not waste time. Let's make every effort to get ourselves in order and save our family the heartache and pain of going through contesting our estates when we pass away, if we do not have a will. Thank you for that. So I take it that every African man listening, will put that into consideration. And also our ladies, most of whom usually build houses without their husband's knowledge in Africa, to get those things in order. So having said that, I would just wanted to ask you, with the probate law and all that, so is the same thing applicable? Again, I know I have asked that. Is it the same procedure, or is completely different in Nigeria? I mean, can you combine your whole assets both here and there in your will and allocate them to whomever beneficiary you want to do in one will, or do you have to have separate wills?
So I'm not really familiar with the rules in Nigeria, because I didn't really practice in Nigeria very, very well to know what's obtainable out there. I can only speak for the US, because I understand the New York State rules when it comes to the probate laws. Okay, for example, in New York, once a disease is gone, for example, a man is deceased, then the wife is there and have 2 kids, for example. The New York State law tells you the wife takes $50,000 automatic from that will, okay? And then now takes half of the remaining amount of money. Then the remaining half will not go to the sibling if the man has children. But if the man has no children, the wife takes everything, right? So, but for Nigeria, I'm not so certain how it works. However, I do know that Nigeria is a common law country, which is the same thing with the US. It's a common law country. So most times there's a universal rule that applies in common law countries. So I'm thinking that the common law rule will be applicable to Nigeria, all things being equal. I don't really see much intricacies in it, because we all apply the common law rule, because the British were the ones that colonized Nigeria. Okay, and even when I was doing the law school program, I saw element of the British law again with something with the US again, because we have the common law country system. So I'm thinking generally it should be the same thing when it comes to the distribution of assets, but I don't know the intricacies when it comes to their own law.
Okay.
So
Thank you.
So when we're really when we mention Nigeria, I'm assuming we're using that as an example.
Right.
So because we're talking African countries in general. But
okay. Exactly.
Yes, thank you. Yeah, thank you so much for sharing that. Yes, go ahead, Ngozi.
So, Mr. Ukazu, another aspect that we would like to touch on today is the guardianship or custody for your minor children. What plans to make for their welfare, well-being, and future plans? So what can you tell us about permanency planning in terms of making sure that our minors are okay and taken care of?
Permanency planning is a process of assessing and preparing a child for long-term out-of-home placements. So if 2 biological parents, for example, decide not to take full custody of their child, they want to allow probably a well-structured process to take place. For example, they might want to give their children to kinship, or they want to give it out to the home care, or they want to give it to a foster agency, or even give it up for adoption. It takes a different process. However, a care plan is very, very critical. That is the center part of everything of permanency planning. And what does that really mean? A care plan takes into consideration the best interest rule, the best interest judgment that will benefit the child. So they take into consideration an assessment, an ongoing assessment for that child, to check the needs of that child and see what will help the child. So if a child, for example, is into custody, for example, a guardianship custody, or into kinship, or in a daycare, what really happens is that the person who's in charge, okay, will take care of the child, and then at every stage, the agency or the body or the institution responsible for that will always assess the child to know how the child is really feeling. And if they feel that the child is not doing well, a different approach can be taken. Also, the court can also come in different aspects to see what will be of the best interest for the child. If that child is not comfortable staying with the surrogate parents, or staying with a kinship person, or staying even with the person that adopted the child, or even staying in the daycare, the court has the power to take that child away from that person and place it in a place that they feel will be of the best interest to the child. So the best interest rule takes preeminence in permanency planning, but basically it's all about, how you care for the long term for that child when the biological parents are no longer there.
Okay, so to make clear so that we understand and some of us are not losing our minds, this permanency plan goes into effect upon the death of the parent or the parents on this, right? And that's when it is activated. The guardian takes over the everyday care of the child. Is that correct?
Well, it takes different shape. For example, if someone was raped, a lady was raped, now she might decide, I don't want to take care of this baby any longer. So that permanency planning can come into consideration. You can see that the person is still alive, but just that I don't want to take rape. Rape is a horrible thing which no woman wants to experience in their life. And not every woman can go with that trauma, if you agree with me. So the lady in question might decide to give that child probably to a foster home or to an agency or for adoption or stuff like that, because you don't want that stuff to happen. And if you have them together, you can say, okay, this child will get XYZ. So it doesn't matter if you're alive or dead, it could take different shape. But the point there is that the parents of the child or whoever has that child might decide, you know what, I don't want to take care of this baby. I don't want, it's just too much for me. Right now I'm not in a good state of mind, because I've seen cases whereby when a woman gives birth to a child, there is thing they call postpartum syndrome or something,
postpartum syndrome,
postpartum,
yes.
or something like that, right? So it's a traumatic experience that can really happen. So sometimes you know what, just take it over for me. It's just too much, So it comes up in different approach. So it must not be when you were dead or alive. It just all depends on how it's been structured.
Oh, okay. All right, it's good to understand that and put that into consideration. And I would also say, as that in terms of single home parentage, where it's a mother or a father, perhaps the spouse, the significant other is already deceased. So it's more imperative than to put these measures into place to make sure that your directives are followed in terms of the care of your children. Is that correct?
Yes, that also you can do, because the main aim of a will, if I may come from that angle, is that you are saying, when I am no longer there, this is what I want to really happen. Okay. Also, again, you can also decide that I am not comfortable with this particular procedure. I prefer this. Okay, and then that generally will take preeminence. However, if what you say is what you want, and the court itself, based on the facts and the circumstances, feel that it will be best suited for the child to work in this area. So if you're saying that I want Mr. A to take care of my child, okay, and then the court feels Mr. A is not doing a good job, that child is not in a good shape with Mr. A or with the agency, the court can take up that child. I've seen cases whereby a lady was like literally saying that this is my child, I want to take ownership and custody, but that lady herself was drunk and she's not in the right mental state. The court took custody of that baby and gave it to the grandmother. So the lady has to go and be visiting the child. So there are so many nuances that comes into consideration when you talk about child custody. What the court does more is that the court applies the best interest rule that will benefit the child.
So then what you're saying is that the courts would vet the person of your choice. And if that's the case, would you advise that parents perhaps have a second person as a standby if perhaps the first person was not fit to do that? Because we may think, because of our personal relationship with somebody, that they have they're the right person, and maybe the church or the court, when they vet and find that this person has a history of child abuse or other violent nature and choose therefore that this is not the right person, should you then fall back on a second person or insist to follow with the first person? And what happens to your child then?
Well, generally, the court respects your will. That is a fact that has to be established generally. However, there are some exceptions that come into consideration. Like I said earlier on, if you decide that Mr. A will take care of your child, and then Mr. A has been there's an evidence or there's a track record to say that Mr. A has child abuse in his record. Now, this is an issue that raises eyebrow or concerns for the court. Definitely, in that case, the court will take into consideration that factor that this child won't be of the best interest, because it makes no sense for the court to abide by the rule when it will not favor the child. When it will not favor the child, the disease made that rule with that honest intention, or in law we say "Ubrima fide," with utmost good faith that this being will take care of my child. However, there's an evidence that this person has track record of child abuse, domestic violence, or even just any of all these funny treatments that won't help the growth of a child. The court might pull it out. So if you have a second party, which is in mind, you may want to try that again, and maybe that can also work. But however, everything now will not determine on what will be of the best interest to the child. That is what the court looks out for. Even though they are looking at your will, this is your will, and it's done. But when it comes to the child custody of a child, that takes a different ball entirely. I don't know if you're familiar with the ACS here in New York. Now, the ACS in New York, they will take up a child from you. It doesn't matter who you are. If your daughter or your son should report that my mom is beating me, that child will leave. I've seen cases whereby a mom told the child, "I'm going to beat you. If you call the cops, that's fine. You know what? They will take you to the surrogates. And when you go there, someone is going to rape you and rape you and rape you." And you get, "Mommy, no, I'm sorry, I'm crying. I will not do it again." That is life. So ACS can be influential. So if you don't want your child to go into that process, you want to do what you think is right.
Okay.
Ngozi, you're mute. Sorry, you're mute.
I'm sorry. So I was saying that, knowledge is power, and we're getting a load of it right here now. So also just wanted to touch on healthcare. Again, we're living in a new normal now. Things are different, and sometimes people go to work, they come back, and before you know it, they're sick simply from going to work, and anything can happen. So what can you tell us about having a healthcare proxy or living will? Is that two different things, or they're one and the same? And how do we prepare to make sure, should we get sick, that we have our directives are being followed to make sure we have the right and best healthcare? Okay,
so the healthcare proxy basically is structured in such a way that you are giving power or authority, let me use the word authority, over your own health to someone else, to the extent you are not capable of making a decision. Let me use the word a sound, judgmental, and coherent decision. So when the end of life process is taking place for someone who is sick, and then the doctors or the medical practitioner feels that you are not capable of making a decision for yourself, now they will ask you before you go into that state, who do you want to make a decision for you? Now that person will now say Mr. A or Mr. B. Now when it now goes to that point, that person now becomes a healthcare proxy. Whatever medical examination that was to be performed on the person, the doctors or the medical or health practitioners will not have to refer to that person. But if the sick person is capable of making a decision, that person will be responsible for everything. And when that goes so bad, you didn't sign that form, that process form, that's it. There's nothing more that can come out of it because you want your will to come into reality. But for the living will, it's all about you saying what you really want. We have a saying in Will's law that the dead man will. So the dead man always wants his will to come into reality when he or she is no longer alive. So living will basically talks about what you'll be doing what should be done when you're no longer there. Okay, that's your living will, that's your life, and you're making your will. But for the healthcare proxy, it's all about you appointing someone to take health decisions on your behalf. And I'll give you a typical example. When my late mom was on that bed, I remember I think my younger sister was the one she gave that right. Not even me, the elder brother, or even my most elder brother could say anything. Nobody's going to listen to them. It's whatever she says that happens. So if that person is an incubator, she will say, take it or leave it. And that's something I don't want anybody to be in that state. It can be traumatic.
Oh, I can imagine that. So what if one does not have this advance directive in terms, I'm sorry, Justin. I'm sorry, I have to get that noise out of the way. So what if someone does not have this advance directive whereby you do not have a healthcare proxy, and then you get sick, you're incapacitated, and you cannot make the best decision for yourself? You're not able to do that. So what happens? Does the family now appoint one person to do that, or the health facility, in this case, the doctors make that decision for the family as to what's best for the person?
Well, I am not give an expert point on this, okay, but I'm going to give a general opinion on this because I think it's more of the common sense approach that will come into reality. Now, when you don't have any of these things spelled out, maybe the healthcare, the doctors or the nurses or whoever is in charge, the healthcare practitioners might want to ask them, what do you want in this case? What do you want? They might give you options. Alternatively, they might decide, this I think would be the best interest for the patient. Do you want it or not? So it all depends on what is going on. So I don't have the expert knowledge to say what's going to happen because maybe a health practitioner might come in, somebody who have expert in that health law might come in. But two things I know for sure is certain. Either the healthcare practitioners will apply the best interest of what is obtainable for the child, for that person who is sick, based on their own experience and expertise in that area. Or two, they can also ask the family, giving them different options and let them know this is what it is. If that family agrees to it, then they now sign the document and say, okay, I'm giving you XYZ based on their own understanding of what they said. And if the family member is there, maybe on their own part, they might want to, you know what, let's proceed with this OR or whatever it is to save this life.
Wow. So thank you so much, Mr. Ukazu, for all this information. It's really, really, really important to always be prepared. And like we always say, knowledge is power. The more you know, the better you can plan. So my people, we've heard Mr. Ukazu. Let's not delay, Death is inevitable again. We will all die. And we may not know when it comes, but it's always good to be prepared, get our affairs in order, do the needful, and be prepared for what comes. That way we make our exit, easier on the people we leave behind. Exactly. So with that being said.
And before you round up, Ngo, because I know you're rounding up, and Ukazu, just because in the African community, right? So going back to estate planning, because with permanency planning, probably you're a single mother or just like you rightly said, an example, you're raped, right? So in these cases, you really, that estate, I mean, permanency planning comes to be very important for you to consider in trying to make sure you get your house in order, so to speak. And with regards to the will, in our community in particular, usually you find that when families or the wife or the husband or even the kids come to start talking about, oh, will, it sounds like a mark for death, unfortunately. So, but
Exactly.
just like you're rightly pointing out, and that is why this information will be very useful for us, for something, for it to be something we need to start thinking about and really start putting in place, to have that understanding that it is not a mark for death. No. And sometimes you find in a conversation, the woman is talking to the husband say, you want me to die? Are you planning? Am I dying? The woman say, why are you talking about will? Am I dying? That's so to speak. So essentially, it is not a mark for death. So it's just like you say, failure to prepare is to prepare to fail. So in essence, it's just to make sure that, well, it's you put your house in order. It makes sure that everything, things go smoothly. Nobody has to go through unnecessary hassles. Whatever property, whether large or big, right? They are distributed, in accordance to how you will feel comfortable, how you will be happy. These assets are being distributed, if even if you were alive. So I really, appreciate that. And one of the things probably you need to reiterate again, and because another mindset we have is that, well, I don't. Writing will is for the rich folks. Those who have properties all over the place, those who have millions in the bank accounts, right?
Oh,
I just got maybe a couple of 10,000. I just have one property. And what am I writing will for? But just like so if you could reiterate that, especially going through it, you have lived experience already. So I mean that would be very helpful. And yeah, so thank you anyway for saying that. Essentially, estate planning is for everyone, and if you failure to prepare, is prepared to fail. You have heard it from the legal point of view, and also you heard it from from our previous episode. Lady Chima, who mentioned that this is really important, being coming from somebody who has gone through the bereavement process, especially during this difficult time, and with the COVID. And now moving forward, God knows what happens to tomorrow. So it is better to be prepared. It is better to have a plan. It is better for us to be equipped. And I hope this information really gets you fully equipped. And on one important point I need to make, it just came to my mind is, usually most of these retirement plans we have also, be it 401k retirement plan, life insurance, our bank accounts. Previously, we may have, assigned beneficiaries to those accounts. And probably that's 10, 20 years ago. It is very important to go back, to see really if the beneficiaries on the accounts, on the life insurance, on the retirement accounts, if those beneficiaries are updated, if those are the, people that are still, active, that you want them to, benefit, from those that arrangement. So have that in mind. And with that being said, I'm gonna hand over again to Ungazi, and she's gonna close us out.
Thank you very much, Dr. CG. Well said. So everybody has heard both from Mr. Ukazu and Dr. Suji's conclusion. So
I'm sorry,
please.
Ungo. Yes, I'm gonna interrupt you again. One important factor I failed to mention is, Henry Mr. Okazu's book, Design for Destiny. Design your destiny. That is a must read, especially now. And I recommend it. Our parents, please get the book for all our kids. They are home during, they are partly home now
I
and
see right here.
partly. Thank you for that. No, show it again one more time. Yes, Design for Destiny. That's Henry Ukazu's book, and it's about leadership. It's about empowerment. It's really just the right tool our kids need for today, and you can find it on Amazon. So please, get it for your kids. Let them read it. It will empower them. Especially now, rather than going out and really nothing profitable. Let them read the book, and I'm sure it will make a huge impact because it is already making waves. So it is good for us to hop on that bandwagon. And thank you. And I promise I won't interrupt you again, Ngozi.
It's not a problem. We all need that information. And again, thank you, Mr. Ukazu, for all the information you provided us with today. It is always, it is a pleasure to have you. And that completes our segment for today. So please, my people, tune in next week for our next section, discussing finances. And thank you all again for joining us. Stay well, stay safe, and have a wonderful weekend. Thank you.
Thank you.
Bye-bye. See you,
Bye-bye now.
Goodie.
Cardi.
Remain blessed.